Cool. Thank you everyone for coming today. This was the brainchild of some people at Philadelphia Legal Assistance, so I appreciate everyone over there for getting this organized. I'm Mike Jones from Philadelphia VIP. Pam. You're on mute. Can't hear your phone.
Okay. Hi, I'm Pam Walsh. I am an attorney in the Health and Independence Unit at Community Legal Services.
Thank you. And so we're all here today to discuss Medicaid and title transfers. Let's go to the next slide. Too many windows. There we are. Next slide. So just so we know what's going on, what's going to first happen is we're going to set some goals for the training. We're going to discuss public benefits and Medicaid eligibility. Pam is really going to discuss that. We're going to discuss what is medical assistance in a state recovery. Then we're going to have some discussions about some exceptions and workarounds. And then we'll have a few scenarios to discuss. We will probably have time for questions at the end, but if you have any questions in the meantime, feel free to put them into the chat and we can get to them as we're going over. Goals for the training. The main goal, there is a lot of information on what we're about to discuss. I don't know all of this information. I'm just learning how to issue spot at this point. And I think what Pam and I discussed is the main goal is to help you issue spot scenarios. You can familiarize yourself with the terms of art and understand the big picture, but your main goal is to say, okay, I see this thing going on in my client's case. I have these questions. Now I know what questions I need to ask and to whom you have to ask them. And that's really like the best place to start for all of this. And now passing it off to Pam.
Okay, great. And I think the answer to the question of to whom you need to ask the questions might be Mike for some of this, but would also be probably people in my unit and including myself, because these are issues that we deal with every day. And so we don't expect you can't be expected to understand all the Medicaid rules here. And this is sort of just to help you issue spot. So please feel free to contact me or my unit or Mike if you run into these issues and you want to discuss your individual case in more depth. All right, so we're going to start out just with a little bit of background on Medicaid eligibility, and just to make sure we all know what program we're talking about, because sometimes people get a little confused about what's Medicaid and what's Medicare. We're just going to start out with what's Medicaid. Medicaid, also known as medical assistance in Pennsylvania, or MA in Pennsylvania, is a means-tested health coverage program for low-income individuals. So it's means-tested. In order to qualify, the person needs to meet income requirements and asset limits, or what we call resource limits. There's a limit on how much they can have in savings and other assets. Medicaid is administered in Pennsylvania by the Department of Human Services, and it's funded jointly by the state and federal governments. And so to qualify for Medicaid, there are some general requirements. The person applying must meet income limits. They have to meet resource limits, which again is assets. And we'll talk in a lot more detail about that. And they also have to meet other eligibility requirements, all depending on the category. To qualify for Medicaid, you have to fall into one of the categories of people who are covered for Medicaid. And there are a number of different categories of people who can qualify for Medicaid in Pennsylvania. So for instance, people who are, there's a newer category that was created by the Affordable Care Act for people who are ages 19 to 64, who have incomes at or below 133% of the federal poverty level. They can qualify for a category that we call MAGI, under the Affordable Care Act. People who are elderly or blind or disabled can also qualify in a different category. Families with children under 21 can qualify in yet a different category. And then there's a category that is the category we will mainly be talking about today. And that's the category for people who functionally would qualify to receive care in a nursing home. They have to meet a functional eligibility test in terms of what kinds of disabilities do they have, and do they need assistance with their activities of daily living. If people qualify for this nursing facility level care and they meet the income and resource requirements, they qualify for Medicaid to pay for long-term care, or what we nowadays call long-term services and supports. And that may either be in a nursing home or in their own home through what we call home and community-based services, which is a menu of different services that people can get in their own home so that they don't have to go to a nursing home. And the most popular of those services that we often hear about is an aide to come into your home, personal assistance services, so that an aide can come into the person's home and help them with bathing and dressing, getting in and out of bed and preparing meals and simple housework. That's a program that a lot of our older clients or clients who have disabilities are in. It's sometimes called the waiver program. It is now run through a program called Community Health Choices. So all of these things are this program that we're talking about, which is about Medicaid-funded long-term services and supports. Next slide. So the main thing we're going to be talking about today is the resource limits, because what we're talking about is property transfers and property. And what that implicates for people who are on Medicaid is whether they meet resource limits. If you own your own home, do you qualify? If you own a second home, do you qualify? If someone transfers a house to you, does that have an impact on your Medicaid? That's what we're going to be talking about today. And someone's just asked, does it matter if the aide is a family member that's paid to take care of them? Yes. It includes that. Home and community-based services paid for by Medicaid, you can either get through like an agency that sends somebody in, or you can employ somebody you know who may be a family member. So yes, it definitely includes that category. So we're going to be talking about resources. And so first we're going to talk a little bit about, well, what resources count in determining eligibility for Medicaid? And it's kind of the things you'd expect: cash, money in checking accounts, savings accounts, stocks or bonds, retirement accounts, certain trust funds, the cash value of life insurance, some vehicles, burial funds, if they're set up in a way that is revocable, which means that the money could be gotten back out of them. And then importantly, for what we're talking about today, what we call non-resident property, which means a property that the person does not live in. It might be a second home. It could be like a family property that their name is on, but they don't live in. It could be a lot. You see lots of cases involving a lot somewhere. Any property that's not the one that the person lives in is going to count toward their resource eligibility and is likely to interfere with their eligibility. We'll talk in a lot more detail about it. Next slide. So here are the resources that don't count in determining Medicaid eligibility. Your primary residence, the house that you live in and own, does not count in determining eligibility for Medicaid. One exception to that is there actually is a home equity limit of, I think it's $636,000 this year. So this is, if someone owns a house and they have $1 million, they have more than $636,000 in equity, that is going to make them ineligible for Medicaid. This never comes up for our clients here in Philadelphia. So your primary residence doesn't count. Certain burial accounts, irrevocable burial accounts, and certain revocable burial accounts that don't have a lot of money in them don't count toward the resource limit. You can have a burial space and a marker, and you can have one motor vehicle, and it doesn't count towards your eligibility. So now we kind of know like what counts and what doesn't count in determining eligibility. What's the limit? So in general, for regular community Medicaid that is not for long-term services and supports, the resource limit is generally $2,000 for a single person and $3,000 for a couple. However, for long-term services and supports programs, it's a little bit different. For people who are receiving home and community-based services through Medicaid, effectively the resource limit is $8,000. Really, it's $2,000. It's just that there's also a $6,000 disregard. And this is because lots of people have cash value and life insurance that was just creating a mess and making people ineligible for services they needed. And so the department decided years ago, okay, we'll disregard $6,000. So effectively, for the program where aid comes into your home, the resource limit is $8,000. For people who are getting their Medicaid in a nursing home, the resource limit is either $8,000 again, or it may be $2,400, all depending on the person's income level. If they're married, their spouse can keep additional resources, and that's kind of outside the scope of what we're talking about today. That's a whole subject on its own. Next slide.
This is me. So now I'll be discussing medical assistance and state recovery. And the people who are affected, these are the, in what Pam had started, the medical assistance eligibility, the category of an adult who is functionally able to receive medical assistance through nursing care or at-home care. These are individuals who are 55 and older and who receive long-term care medical assistance. So those are people who are receiving at-home care, community-based care, or nursing home care. And that means that they are currently receiving that care. What is affected is affected in their probate state. For a state, for the most part, what that means to us is it affects their home. And it is affected because when, and I think we're going to get into this in another slide, but ultimately these programs will need to use the property that people currently own and live in as kind of a means of paying for the program in later dates. And so they are using these probate estate to pay for the program. If the person is living, there is no lien on the property. That means that the lien only exists upon the death of that person. So who is affected by estate recovery? I kind of delved into this. This is a deeper slide, but individuals who are 55 or older and receiving community health choices medical assistance through services of nursing facility, home or community-based services, or any related hospital care and prescription drug services provided while receiving those nursing facility cares or home and community-based services. If you've ever received your statement of claim for a decedent when you are assisting in probating their estate, you will see that there is potentially a number of prescription drugs and other hospital care bills that have been included in that. Additionally, a specific program, participants who are 55 and older and living independently for elders, the LIFE program, they could also be affected by medical assistance, estate recovery. So as I mentioned, there is no lien that occurs until after the death of the recipient. And at that time, DHS is required to recover the funds that paid for the medical assistance from the estate of the deceased recipient. And so the purpose is to recover these costs for long-term care. It doesn't happen until after the person dies, and it applies to the services that they received when they turned 55 and older and began receiving the long-term care for medical assistance. This is based in our statutes and regulations, and we just cite that here. So as I said, this is affected by the probate estate is what is affected. And so anything that is in a probate estate for the decedent can be held as, there can be a lien against the property in the probate estate. So all assets that pass to the heir through will or intestacy law. And that is, for our clients, the majority of the time, it includes their property and generally solely their property. Probate estates do not include assets where there are beneficiary designations, so retirement accounts, but also those that are held jointly. So anything that is rights of survivorship, joint accounts, tenants by the entirety, but that's a separate thing that we can get into. How is the home affected? So the house owned by the recipient spouse, by tenants by the entireties, or with right of survivorship is not subject to estate recovery because this is outside of the probate estate. These things are not probatable assets, and therefore they're outside of it. In addition, there is a surviving spouse in the event that there is a property is held not by tenants by the entirety, but if there's a surviving spouse, the spouse can receive a postponement, but that's, again, another little facet. If the house is in the recipient's name only, DHS can still recover until the spouse's death. The house may be owned with right of survivorship with a non-spouse, so a child or a sibling. If the joint owner survives the recipient, then the house passes to the joint under the terms of the deed, and the estate recovery does not apply. That is because, again, it is not probate. It is not a probate asset. It's not a part of the probate estate. So if there are estate recovery, if there is an estate recovery claim, there are a few ways to try and preserve the home and get that claim either postponed or waived. So there's a postponement and waiver. And here's a note: if estate recovery does not count if the homeowner died before August 5th, 1994. If the homeowner never used medical assistance to pay for their long-term care, or if the homeowner only received short-term end-of-life care, such as hospice. This means that, again, there is no estate recovery in those cases. So postponement. DHS has a number of kind of relationships to a person who is taking title to the property. Will say that they will postpone the estate recovery and not collect on the lien. You'll still need to actively go through the process of communicating with DHS, but if the surviving spouse is was not on the deed initially, so that the property wasn't held as tenants by the entirety, then the surviving spouse can get the estate recovery claim postponed. If the decedent had a adult disabled child or an adult disabled child who is living in the house or no longer living in the house, that means that they can postpone the estate recovery claim until after the death of the disabled child. If there's a minor, they will postpone the estate recovery until that minor turns 21. And then additionally, if there is a sibling who is equity interest in the property and has lived in the property for 1 year prior to the death of the recipient, they will wait and postpone the estate recovery claim until the death of, or the property transfer, or the vacancy, like the sibling leaving the property. So DHS will place a lien on the property to protect its ability to recover after the postponement ends. I think that I've never actually experienced the postponement being foreclosed upon, so I can't speak to any of the actual procedural scenarios that happen there. But I have a question. We have a question. What if the adult disabled child is off to college? Does that count as no longer living in the house? Pam, do you want to?
I haven't seen that come up. I would imagine that as long as the adult child said that they still considered it their primary home and that they were just temporarily at college but coming home for holidays and summers, that I would imagine that DHS wouldn't consider that vacating the house. That's my assumption. You'd have to check if it came up. We've got another question here about what exactly do they do to place the lien? Do they record it somewhere, perfect it somehow? Mike, do you want me to answer that? I have actually dealt with that.
Yeah, please.
Okay, so in this situation, DHS's estate recovery unit will, they've got a 2-page document, which they call a mortgage. It's essentially a lien that they put particular language into explaining that they are postponing the collection, that they have a claim, that they're postponing collection and why, and the circumstances under which they will, resume efforts to collect. And what they do is they send that document, that mortgage, out to the person or to their attorney, and they want you to sign it. They want you to have the client sign it and then record it down at the recorder of deeds down at City Hall.
Madeline, I see you have a question. We'll get into that in the next slide. In addition to postponement, if your client or is a recipient, or rather, if your client has a relationship with a recipient decedent, you can also get a hardship waiver. So after the client receives the statement of claim, you can consider applying for a hardship waiver. There are certain qualifications that they have to meet to get that, but I think this is an or, not an and, but criteria for receiving a hardship waiver: the administered estate with gross value of less than $2,400 if there's an heir. So that property could receive a hardship waiver. An asset which is income producing or used in trade or business, that could receive a hardship waiver. And this should be an or, not an and. The client meets all 3 of these following requirements. And this is usually the rub for our clients. They provided care for decedent for at least 2 years before receiving nursing care, or at least 2 years while they were receiving at-home care. They lived in the property for that 2-year period and have proof of that residency, and they have no alternative permanent residence to live in. I will say, from personal experience, working with clients, even if the client doesn't necessarily meet these requirements and they don't have all the proof in the world, you should always apply to try and get a hardship waiver. I don't think that it really hurts, in my opinion, and it's possible that you could ultimately get one through compelling reasons. So, Madeline, it depends on, for your question, which is if a decedent has an adult child living with them at the time of the death and they are elderly themselves, I'm assuming that's the adult child, can they get a postponement or a hardship waiver? I would imagine that depends on certain factors. If the elderly child was providing care for the decedent, then I would say that absolutely should try and go for a hardship waiver. There's proof that they've been living there. Proof that they've acted as a caregiver can come in many forms, but the Department of Human Services has relied on a letter from either a doctor or someone who has personal knowledge but doesn't have an actual interest, like legal interest in the property. They can rely on a letter that says that. Proof of residency, if you have that, that's, in my opinion, sometimes the hardest thing to get, is because we often have a decedent who died many years ago, and proving that they lived in that property 2 years before that is difficult. So additionally, other hardship waiver requests, you should try and seek a hardship waiver if you are kind of on the edge of eligibility, and including compelling reasons could always be to your benefit. I mean, these are human beings who are reviewing this and making decisions. So making your client human is always very, very helpful. I think, Pam, passing it back to you. You're on mute again.
Sorry about that. Could you go back one slide? I just wanted to add something quickly. I just wanted to say, and actually even one slide back. I just want to emphasize this, the text near the bottom. Even if, which is that the department has the authority to waive a claim or compromise it, take less than the full amount, or postpone it in other circumstances besides the ones where the regulations say that the client's entitled to a hardship waiver or entitled to a postponement. They've got the authority to do it in other circumstances where there's like another form of undue hardship that's not covered by these criteria, or if collection is not cost effective. And so they can look at cases on a case-by-case basis and determine this. And this sort of goes to what Mike was saying about other, making an argument about your other circumstances that to argue for an undue hardship waiver. It used to be that we would do this and we would just throw in all the compelling circumstances that we could think of, including, like, I took pictures of people's kitchen sheds falling off the back of the house or bad conditions in the house, and sent in information about how little it was worth and explained about every health condition everyone in the house had and every other sympathetic fact. It used to be that we were routinely successful with that and would get hardship waivers. In more recent years, the department that decides this and the panel that actually reviews them have gotten a lot more rigid and will say, but you don't meet the criteria exactly. You can't get a hardship waiver. That's not what the regulations say. They can determine these on a case-by-case basis. And so you may need to point this out and push a little bit to get them to really seriously consider where your facts don't quite line up with theirs. And keep in mind, you have the right to appeal if they deny a hardship waiver, and they are really not used to getting appeals, and that will get them to keep talking with you in order to try to resolve your appeal. Sometimes what they will do in situations where you don't quite meet the hardship waiver criteria is they'll give you a postponement, which is not as good as a hardship waiver, because a hardship waiver makes the claim go away forever. But a postponement can still be a lot of relief to a client, so they can keep living there. Okay. Next, go forward 2 slides now. Yes. So I'm going to talk now about title transfer and how that can impact Medicaid eligibility, because I think this is where this really comes up for your practice. And we're going to go over a few different topics in this. We're going to talk about the look-back period, which is the period of time that the welfare department looks back through the applicant's financial records to see if they've given anything away. And we're going to talk about which kinds of transfers create a penalty period. And we're going to talk about exceptions, transfers that do not create a penalty period. And then finally, so these 2 categories are about giving something away. But I think the other place in which this may come up for your practice is if you're adding your client's name to the title of a house. That could create Medicaid eligibility issues as well. So we're going to talk briefly about that as well. All right. So, so given everything we've just heard about estate recovery, it is obviously tempting for people to give away their assets in order to avoid estate recovery. However, Congress does not want that to happen, and so they have amended the federal Medicaid statute a number of times over the years to try to foreclose the ability of people to do that. And one way in which they try to keep people from transferring assets in order to qualify for Medicaid or to avoid estate recovery is that if individuals give away assets for less than fair market value, in other words, for less than their worth, it will create a period of time in which the person is not eligible for Medicaid. They'll be penalized. The way that this works is that when a person applies for Medicaid, the welfare department will ask for bank records going back 5 years, and they also ask on the application, have you given away anything of value in the past 60 months? And the person has to answer truthfully in order to not be committing Medicaid fraud. And if the person has given away something of value, sometimes it's money, and that's kind of outside of what we're talking about today, or other times it may be a property that they've transferred. If so, the county assistance office is going to consider whether it was transferred for less than fair market value, whether an exception applied, and if not, whether they should assess a period of ineligibility. So the period of ineligibility is calculated by dividing the value of what was given away by basically how much it costs per month to be in a nursing home. So as an example, let's imagine that I give away a house that's worth $120,000. I gave it to my son. It doesn't meet any exceptions. And then I apply sometime in the next 60 months for Medicaid for long-term care. County Assistance Office will take the value of what I gave away, $120,000, and they will divide it by it's either a daily rate or a monthly rate. You can do the math either way. They'll either divide it by $11,000 and figure out the number of months I'm ineligible, or they'll divide it by this amount, $364.90 a day, and figure out how many days I'm ineligible for. And then they will send me a notice saying you transferred property for less than fair market value. You are now ineligible for Medicaid for long-term care for the next X month. So in my example, $120,000 divided by $11,000, I would be ineligible for approximately 11 months, if I'm doing the math right. And so that penalty period begins if you're just applying on the day you'd otherwise be eligible for Medicaid for long-term care, or if you're a recipient and you do it after you're already on Medicaid, it'll start the first day after the month that DHS becomes aware of it and issues a notice about that. I got a question from Joanne. Does this 5-year look-back period apply to all Medicaid eligibility or just Medicaid for long-term care? And the answer is just Medicaid for long-term care. It does not apply to plain old community Medicaid. So the reasoning for the penalty period, of course, is to sort of take the value of what I gave away and make me ineligible for the period of time that money could have paid for my care in a nursing home. So giving away a property entirely will make a person ineligible, but also disposing of property for less than it's worth also will. So if I have a house that's worth $120,000 and I sell it to my son for $60,000, I've basically given away $60,000 worth of equity. And so the amount that's considered a transfer of assets would be $60,000 in this scenario. Adding people's names to the deed also counts as a transfer because you're giving away partial ownership of your property. So as an example, if a mother adds their adult son who doesn't meet an exception onto the deed, that's going to be considered a transfer for less than fair market value, and they will calculate the value of what was given away by doing that and assess a period of ineligibility. Next slide. There are certain exceptions. And this is from the federal Medicaid statute, and if anyone wants citations for any of this, I'd be happy to provide them. It is, if you transfer the home, first of all, there are certain things that you can do. You can transfer your home to your spouse at any time. You can transfer your home to your child if they are under 21. You can transfer your home, and when I say your home, like primary residence, you can transfer it to an adult disabled child, which is defined as your adult child who meets the Social Security disability criteria for disability. You can also transfer your house to your sibling if they've got an equity interest and have lived in the home for at least a year. And you can transfer your home to your son or your daughter if they lived in the house with you and provided care to you for at least 2 years immediately before you began receiving Medicaid for nursing home care. Or for at least 2 years. The way that the welfare department tends to do it for home and community-based services is for 2 years while you were getting HCBS. So the idea of this last bullet point is if there's an adult child who moves in with their parent or continues to live with their parents and provides care to them, which enables the older adult to stay home and avoid needing Medicaid-funded long-term services and supports for 2 years, we will say yes. You can transfer the home to your son or daughter because we don't want to penalize them now. You've provided care. You saved the taxpayers' money. We're not going to kick you out now of the home after the person dies through estate recovery. There are other exceptions. You can transfer any assets, not just the home, to an adult disabled child, or to a trust for an adult disabled child, or to a trust, or you can transfer assets also to a trust established solely for the benefit of a disabled individual under the age of 65. So this doesn't even have to be anyone who's any particular relationship to you. It could be a granddaughter or anyone who is sort of the, that you would want to set this up for. And then a really important category of transfers that should not create a penalty is when the person transferred the property exclusively for a purpose other than qualifying for Medicaid, and exclusively for a purpose other than avoiding estate recovery. So if the person transferred their property, but it had nothing to do, they weren't thinking about Medicaid, had nothing to do with trying to qualify, it didn't have anything to do with trying to avoid estate recovery, that's actually a transfer that should not be penalized. The welfare department tends to automatically impose penalties and not really think this through. And so they really have to be reminded of this. And so an example is a transfer that someone did at a time when they were absolutely not thinking about the possibility of ever needing long-term care. I had a client who was in his 40s or maybe 50 years old, healthy, working, had never given any thought to long-term care. Tragically, he fell down his basement stairs and was rendered quadriplegic. He needed nursing home care. He never would have guessed that would have happened to him. He had given away some money prior to that because for reasons that had nothing to do with long-term care. The welfare department said, you transferred assets, you got a penalty period. And we just responded, look at the facts here. This is someone who had no idea he was going to need long-term care. He was clearly not doing it in order to qualify for Medicaid, and they had to agree and did not impose a penalty. So some of the things the welfare department will look at in determining whether you transferred it for a purpose other than qualifying for MA would be, one, well, what was your purpose? Is there another clear purpose, another reason you did it? And then also, how likely is it that this person is going to need long-term care soon? If the person is younger or relatively younger, in good health, completely independent, does not yet have a condition that might make them need long-term care, it is more likely that it will be considered that it was not for the purposes of qualifying for Medicaid. There is a case on this, a Commonwealth Court case called Go Down versus DHS. And this was a case where a couple who were about 85 years old transferred their home, which I think had a business connected to it, to their children. They then immediately applied for Medicaid for long-term care. And the department assessed the penalty period. And the Go Downs argued, nope, we didn't do this to qualify for Medicaid. We were just doing this because we're older and it's time to hand off our assets to our children. And the Commonwealth Court said, at the age of 85, it could have been expected that you would need long-term care sometime soon. DHS is entitled to presume that the purpose was to qualify for Medicaid, and in that particular case, they will presume that it was to qualify for Medicaid. So in general, DHS will generally will presume that the purpose of a transfer is to qualify for Medicaid, but there is a process to rebut it. And then the last thing I want to say about this is that if the person does incur a penalty period, they can ask for an undue hardship waiver. It's hard to get in the context of long-term care because what you have to show is that either not getting it would deprive you of medical care, endangering your health or life, or that it would deprive you of food, clothing, shelter, or other basic necessities of life. So if you can show that you won't get the care you need, and that it will endanger your life, you should be able to get a hardship waiver. However, if a person's in a nursing home, the nursing home actually cannot kick the person out without transferring them to a place that will meet their needs. So so what that means is it's really hard to show that the individual is going to be left without the care they need, because the nursing home is sort of stuck with them. The nursing home, meanwhile, will not be getting paid, and what they will do in return is they will file a lawsuit against the resident, their spouse, anybody else who was sort of on the scene and was involved in the transfer of property. So just keep in mind, there is an undue hardship waiver that can be sought. It's not easy to get in this situation. Next slide. So I think the takeaways that we want you to get from this are that giving an interest in a home away for less than fair market value in general will create a penalty period, a period of ineligibility. And they'll look at the 5-year look back period to see, during that 5 years, did you give anything away in order to determine that. And that is unless an exception is present. As you saw, there's a lot of exceptions in which it is okay to transfer property. If you take your name entirely off a deed while receiving Medicaid for long-term care, again, you generally can't do this. It'll create a period of ineligibility unless an exception applied. One way in which this can surface is that people who are receiving Medicaid for long-term care do an annual redetermination. And at this time, they have to fill out a new application form. And one of the questions on the application is, have you given away of anything of value? And so if you've transferred your house or another property, you have to be truthful, you have to put that on there, and that will flag for the welfare department that there is a potential transfer for less than fair market value. The other thing that we wanted to talk about, so largely we've been talking about taking people's names off deeds, which triggers all kinds of issues, but putting a client's name on title can also create issues for Medicaid eligibility. And the primary one is if you are contemplating adding a client's name to a deed of a property that they are not going to be living in, this can potentially create an eligibility problem for them for Medicaid and for SSI, because this will mean that they own non-residential property. They'll own a second property they don't live in. It's then going to count as a resource in determining their eligibility for Medicaid and for SSI, which we'll talk about in a little bit. And so if you're putting their name on a property that will be their primary residence, that's fine. But again, second properties, if you're ever doing that, you really should think about what benefits is this individual receiving? Am I going to be interfering with their eligibility for those benefits? The other thing to think about is, let's say you have a client and the goal of the representation is to get their name on a deed. And let's say they are older. Keep in mind that if that person is either receiving Medicaid for long-term care or is likely to sometime in the near future, a state recovery will be an issue for them after they pass. And so you just want to think that through. If you're thinking about, adding an 80-year-old client's name to a deed, keep in mind that if they're getting Medicaid for long-term care, after they pass, it will be subject to a state recovery. And if the goal was to keep the property in the family, that may not happen if it then is subject to a state recovery. So one thing to think about doing in that situation, maybe rather than putting just the person's that person's name on the deed, is there another family member that you want to include on the deed as well, with right of survivorship, so that it passes outside of probate to the other family member. But again, as you do that, you would only want to do that if it doesn't have the effect of giving something away. Otherwise, you've got a transfer of assets issue again. Are there any questions we want to take right now, Mike?
Yeah, there's a, actually, in this, on this page, there's a, the first question is, what is a timeline for estate recovery, which actually kind of matches up with a prior
Oh,
question that was asked by Joanne,
okay.
which is there a statute of limitations for these liens? Does the department have to do something to revive the lien at any certain point? And I think this kind of goes hand in hand with the timeline and how much time does
Yeah.
one have?
Okay. So there's no statute of limitations. We can talk a little bit about the timeline. After a person who received Medicaid for long-term services or supports passes, the personal representative for the estate has a duty to ascertain whether the person received Medicaid in the 5 years prior to their death. And if so, the personal representative is required under these, this is in the estate recovery regulations. They're required to seek a statement of claim from DHS. So you're basically notifying the department, this person passed away. Do you have a claim against their estate for receipt of Medicaid for long-term service and support? The regulations explain what has to go into this statement of claim and where to send it. DHS has an obligation to respond within 45 days. If it doesn't respond by that time, the claim is forfeited. So they will hopefully respond within 45 days. And what they will do is they'll send out an explanation of what their claim is, if they have one, along with an itemized breakdown of what services were provided and how much they cost. And they'll assign a claims investigation agent who will also have a whole bunch of questions and will enter into sort of a dialogue with you about how much is the property worth, and ask a lot of questions that you can start kind of working through the case with. Next question is, how much time does one have after the death of a beneficiary before they're in danger of losing their home? The answer is, this is not a fast process. After the statement of claim is requested, there's often, if people are unrepresented, there can be a very long period of time in which people are not quite sure what to do, aren't represented, just want to ignore it completely because they're afraid they're going to lose the home. And what will happen is that the estate recovery unit within DHS will keep sending out letters for quite a while. And when I say quite a while, I mean really months, couple of years. And then, if they ultimately come to you, and you still have some time to engage with the department. Nothing happens very rapidly. Liens aren't placed immediately upon the person's death. I mean, really, the only time a lien is placed is if a postponement is granted, and the department then places its lien on the home. What the department has when the person dies isn't so much a lien as a claim. And I'm not a property attorney, so I don't know if that really legally equals a lien, but there's certainly nothing filed upon the death of the person. If the person takes years and just ignores the letters and does nothing, DHS may do one of a couple things. They'll keep sending a lot of letters. We've seen cases in which they ultimately just give up and go away. Or DHS has the power to contract with a private attorney and have the private attorney administer the estate themselves. And so they would administer the estate and pay off the creditors, including, of course, DHS. And so we sometimes see cases where that process has gotten started and an attorney is now working on administering the estate. And in that situation, you've got to deal with that attorney. Even at that point, it's really not too late. If you have a case for postponement or a hardship waiver, you can still ask for it at that point. Can someone qualify? I think we've sort of covered the next bullet point. And then we'll talk about South Philly trusts in a little bit in one of our examples. Next slide. I just want to quickly talk about SSI because that's another program that a lot of our clients receive that's implicated in property transfers. SSI is a disability program for people who are disabled but who don't qualify for Social Security disability or only qualify for a small amount of Social Security disability. It's another means-tested program, and it has a $2,000 resource limit. It also has a prohibition on transferring assets. rules are slightly different. Its look-back period is only 36 months, and it is, and the penalty period for SSI is calculated by dividing the value of what you gave away by the monthly SSI rate, which this year is $841. And the maximum period of ineligibility is 36 months. So just keep in mind that when people are considering transferring properties, it's not even just the MA. If they are a younger person or a person of any age on SSI, this potentially will affect their SSI too. Next slide. And one thing to know about this is that the transfer of the primary residence in SSI does not result in a penalty period because your house does not count in determining eligibility for SSI, and therefore giving it away has no effect on Medicaid. There's no estate recovery for SSI, so that issue doesn't come up. So transferring your primary residence is actually doesn't create a period of ineligibility. And there's a sub-regulatory rule called a POMS, and there's a link to it that says this. If for SSI, if someone does give away property, they also, and there's going to be a penalty period, they also can request an undue hardship waiver. And this is actually a little bit easier than in the Medicaid context. You have to show that imposing the penalty would deprive the person of food or shelter, and that their total available funds, which is defined as your the income that you're still getting, even though your SSI is cut off, plus your liquid resources, the money you've got is less than $841, which is the monthly SSI rate. So I had a client who was in her 80s. She had surfaced that she'd given away a family home. She was going to have a huge ineligibility period. However, without her SSI, she would have no income, and she had less than $841 in the bank. And so we were able to get her an undue hardship waiver. Next slide. You want to move into the scenarios now, Mike?
Sure. I think there are some questions, but we can get to questions at the end. So first scenario, we've got three scenarios. First scenario is client is 65 and lives in a house owned by her older sister. The client currently receives medical assistance, and her sister wants to add the client to the deed because it's a family property. What are the things that we need to think about? So a few questions that we need to ask are, will adding the client to the, will adding the client to the property impact her medical assistance eligibility? Pam?
Yep. So in this scenario, it's not going to be a problem. I'm sorry, I'm in the wrong scenario. Hang on. Okay, so
client
sorry,
is.
We reversed them.
Did we reverse them?
Which one is this? I'm sorry.
This is the, no, I think you're right. The client is 65 and lives in the property.
Oh, this is the older sister. Okay, sorry about that. So in this one, so the first answer is no. It will not affect your client's medical assistance eligibility because she lives in this property too. So it's going to be considered her primary residence, and so she will remain eligible for medical assistance.
The third bullet point is, will this transfer affect the older sister's ability to qualify?
Yeah. Well, the second one is, what if the client does not live in the house? If she did not live in the house, yes, it would affect it because she would now own non-resident property, and whatever the equity of that is divided by 2, because she would own it with her sister, would count toward her $2,000 or will count toward her resource limit, and would probably make her ineligible. Our third question is, the other thing to think about in these situations is it going to affect the other person's ability to qualify for Medicaid? Because you've got her older sister now giving away property, and it could have an impact on her benefits. And in this case, it likely would. There's an exception for transferring a property to a sibling who has an equity interest in the property and has lived there for at least 1 year. But in this particular case, we don't have any information to suggest that our client has an equity interest in the property. If she did, it would be permissible. If not, it's probably going to create a period of ineligibility. Another thing to look at here would be if you wanted to make an argument that, oh, sister's not doing it to qualify for Medicaid, she's doing it because she wants to own this family property with her sister. She wants to have it in the family. She's doing some planning now. I think what the welfare department would likely look at is it foreseeable that the sister will need long-term care anytime soon? Is she really healthy? Is she completely independent? Does she have any conditions that are likely to mean that she'll need long-term care? And if there's some good reason that's really not about Medicaid, all of that will help in arguing that it's not about qualifying for Medicaid. Something to think about here is that the older sister may need her own counsel and her own legal advice because her interests are at stake as well. And an important thing always to think about in these kinds of cases is who is your client, and to keep straight that you're not representing both of them. You can't advise both of them probably here because there is potentially a conflict. Your client is the first client, and the other one may need representation. If the sister really does want to move forward with the transfer, it would probably be a good idea to check this out with DHS's counsel, which is something that is going to come up in some of the other scenarios. In situations where you're considering a transfer and you think that it may it may create a period of ineligibility for someone, you may want to check with DHS counsel to see if they would consider it okay, and they can issue a confirmation that it's a permissible transfer if they think that it is. And then finally, if the client's name is added to the deed, what will the impact be on estate recovery? So now we've got both sisters' names on the deed. And I'm assuming here that we would be doing this with right of survivorship, because if you do it as tenants in common, that's going to create a whole new problem. When, let's say, our client dies first, if she dies first, the welfare department will have a claim against her half of the property, and that's going to be a problem for her sister. If the deed is titled as tenants with right of survivorship, on the other hand, if our client dies first, her sister will get the property outside of probate, and there will be no estate recovery. Sister can keep the house. If the older sister dies first, our client will own the house all by herself, and thereafter, if she passes, there will be estate recovery again.
Pam, how do you determine a sibling's equity interest?
That is a great question. And I'm not sure I've got a great answer to it. I think I've not seen any case law on this. I think it would, and I'm not a property law attorney either. I think it would be if the sibling has some argument that they are entitled to a share of ownership. And I guess this would probably most likely come up if it was a family property and there was a question about who should be the heirs, really, despite whose name it may be in. I imagine there may be other such scenarios in which someone could make a claim that they have an equity interest in a property. I'm sorry, I can't be any more specific than that.
That was my gut feeling too. Next scenario,
Okay.
Client is 65 and lives in a house that she purchased many years ago using money that her daughter inherited when she was a minor, when the daughter was a minor. Client does not receive medical assistance and lives a healthy and independent life. Client would like to transfer her property to her daughter because it is, quote, really daughter's property. How could client ensure that this transfer will not make her ineligible for medical assistance?
Yeah. So the first thing to check, because just the easiest way to do this, is does the daughter qualify for an exception anyway? Is the daughter an adult disabled child, or has she provided care for at least 2 years for the individual, in which case she'd qualify for an exception and her mother can transfer the property to her regardless of whose house it was originally. But assuming that she doesn't meet an exception, she still may be able to transfer the property to her daughter. This is a scenario we've seen a number of times. In the case that I had, client had bought a property for her son when he was a minor with his SSI retroactive benefits, and she was told at the time that his name couldn't be on the deed. So she took his retroactive benefits, she bought the house, she put her name on the deed, and things just kind of went along like that until he was 30 and was living in the house and really wanted to have it in his own name. But mom at this point was getting home and community-based services. And so we didn't want to mess that up. So what we did, and what people often do in this situation, is to contact DHS's Office of Legal Counsel, and there's an attorney there. There are a few different attorneys who handle long-term care issues. The one that I deal with the most frequently is named Leslie Oaks. You can contact her by email. That's the way she responds best, and run your scenario by her and explain the situation. And if she agrees that yes, this is a permissible transfer, she will respond, usually by email, saying, yes, this is a permissible transfer. You can do this. You can then tell, she'll say, the county assistant's office to contact me, Leslie Oaks, if they have an issue about it. And so it's sort of a process of getting a transfer blessed, sort of what we say, by the Office of Legal Counsel. And so in my case, with the person who had used her son's SSI money, we got her proof that there had been SSI money. I think we were able to show that the house was purchased right when they'd gotten the SSI money. And we explained why the deed had ended up in mom's name, and she approved the transfer. It was clear to her that the money was the son's, and that the transfer was for the purpose of putting the house in the name of the person who really should own it, because he had paid all the money for it and was living there. So there are a lot of different permutations of this fact pattern, some of which are unfortunately not quite as clean as that one, where you can check, you can go to their counsel and make your best argument and try to argue that the house really should be owned by somebody else. Can we do this transfer? Another common, related scenario that we've seen surface a lot recently is where you're working on a case and somebody wants to do something with a property, transfer it to someone, and it surfaced that the person who currently owns it is an elderly person or a person with a disability who's already getting Medicaid for long-term care, and it's not their primary residence. So in other words, it's a property that this person owns. It's a non-residential property that somehow has not been reported to the welfare department, and but the person's already getting Medicaid. The owner is already getting Medicaid. The problem with this is what you just surfaced is that this person owns a property that they're not actually eligible for Medicaid. And if and when the welfare department finds out about this, the person will be cut off from Medicaid. They may have an overpayment. This is a problem that person, who is maybe not even your client, needs to deal with. And so in that scenario, that person needs their own legal advice and their own legal counsel, and you may need to make a referral to make that happen in order to try to come up with some sort of resolution, maybe transferring it if that's permissible, or doing something else to try to preserve Medicaid for this person who we now know owns non-residential property. Do we want to take questions, Mike?
Sure. We had a nice question from Joanne that I think I could summed up. I'll read the whole thing actually. If someone transfers an equitable interest in the property, does that also count as something of value if the property was never in the person's name? For example, a homeowner dies and leaves two heirs. The homeowner who died did not have an estate recovery issues themselves. The client is an heir of the property and lives in the property. The other heir does not live in the property and was planning on transferring the property to the client. Before the transfer, the heir, who is not PLA's client, has a stroke and is now in long-term care.
I'm not sure I got all the facts. I'd be happy to talk with this person about this in more detail later, but in general, I will just say that if a person has an equitable interest because they're an heir and they give it away, that is in fact considered a transfer for less than fair market value, because they are entitled to that. I think there's a question about at what point DHS considers it your property, but you can't give away property that you have an equitable interest in, for which you are an heir, but just hasn't been put in your name yet. And I'd be happy to talk more about the facts of that.
Someone asked if a DHS lien for estate recovery would come up in a title search. My guess is that if there's a postponement and it's been recorded, it would be, although I don't think that there's any other way for DHS to have a lien that would show up in public searches that could be found through a title search otherwise.
Yeah, I'm not sure about the answer to that. But I do know that if a property is transferred to someone else, the personal representative will remain liable. So if you're the executor and you sell the house to someone else, or you transfer it to some other heir, you, the personal representative, are going to be on the hook and liable. So the problem doesn't really go away at that point.
No, I don't think it'll. I've looked at enough title reports. I've never seen a DHS estate recovery claim that shows up there. So I know it wouldn't appear there. Emily asked if estate recovery will only be for properties owned in Philadelphia County. It's my understanding that is across Pennsylvania.
Yeah, and in fact, this is a national requirement. Each state handles it slightly differently, but it's definitely across Pennsylvania.
We've got a question from Todd for estate recovery liens. Do they move to foreclose on the house, or is it just a lien to be paid before the sale of the house?
So in the case of postponement, it's a lien and it just stays there until the person passes away. I've actually never seen sort of the aftermath of that in terms of what happens. In terms of foreclosure, I think you're probably talking about like what would they do if everyone just ignored the, didn't resolve the estate recovery claim. And what they will do in the end is not foreclosure. What they will contract with a private attorney to administer the estate and have the attorney, administer the estate and pay them off as a creditor. So sell the house basically and pay them rather than a foreclosure. Yeah.
Is there any, if like, let's say you're working together with DHS and we have a client who is living in the property but doesn't qualify for undue hardship, doesn't meet postponement eligibility, and doesn't really have the compelling story that the panel would feel is worthy of meeting that case-by-case basis eligibility, and they say, sorry, there's nothing we can do. Do they go through foreclosure, or do they go through a similar kind of process where they, cash for keys kind of a thing, handing over the keys and saying thanks?
Yeah, I think what they would do is they would say, we want you to pay us this money. And people should keep in mind that the amount of the claim isn't necessarily the value of the house. It's just the value of the claims. The house may be worth more or less than that amount. I think what they would do is, keep making keep sending statements demanding their money. And ultimately, if there was no response, they would either give up or contract with a private attorney to administer it, sell the house, and pay them. Another thing to keep in mind in that scenario is that DHS will also compromise its claims. And so sometimes what people can do in that situation is offer, partial payment if they can, afford, if the claim is $50,000 and they can afford to pay $20,000 and that's all, they can offer that much money and try to resolve it. And DHS may figure that, a bird in the hand is better than having to hire a private attorney and go through all that expensive process.
Jumping back to what does fair market, how do you establish fair market value for the asset?
Yeah. At DHS, I'm sure would love to have an appraisal, but usually they will use the tax assessed value as that, which is, I think, helpful to us because it's usually, it's easier for our, to get for our clients, and it's usually not super inflated.
I think those are the questions that have been asked, unless I'm missing anything.
Okay. Do we want to do this last scenario? I know we're a little over time.
Sure. Yeah, please.
Up to people. I guess people can stay if they wish. So this is, I think, a scenario that may have been someone's actual case. Client is elderly and getting MA long-term care. She lives in the house she owns and she's getting home and community-based services. In 2016, she transferred the deed to herself as trustee for her adult son, who is living in a nursing home. So, and we'll just say that that deed is basically a South Philly trust. Client wants to protect her home from estate recovery so that her son can have the home and move in when he's ready. However, he has not lived in the home for several years and has no prospect of returning home anytime soon because there is insufficient infrastructure in the home to meet his needs. So this is interesting, partly because of the South Philly Trust. The first question is, so she's currently got a deed that is her name in trust for her son, and the trust language is this, what we call the South Philly Trust, where she still remains free to sell it, to mortgage it, to rent it, to live there, do whatever she wants, but it passes to him at her death. And my so just to start out, like, so what's the impact of that on her Medicaid eligibility? And on state recovery, if you just leave it as it currently is, my understanding is that, you know, the effect of the South Philly Trust is similar to tenants with right of survivorship in that it would pass to him upon her death outside of probate. And if so, I think he would be safe from estate recovery. However, I was told years ago by an attorney who, at that time, was a longtime attorney at DHS, that this scenario actually creates a problem for her Medicaid eligibility, because by having it in a trust rather than just a regular deed in which she owns it in fee, it somehow takes it out of being considered just resident property, but instead is considered trust property, which is not exempt from being considered a resource. If you've got this case, I think it would be a good idea to follow up with this attorney, with Drew Coates, who's this attorney, to understand that better than I am remembering it. So I think in her current situation, she could have an issue about her current eligibility. However, I don't think the welfare department would be likely in this scenario ever to surface it while she's living, because she's already on Medicaid. The county assistance office doesn't go back and look closely at deeds, and I don't think they really have any notion of what a South Philly Trust is or what its impact is on eligibility. Where it could come up is after she dies, when estate recovery is being dealt with. If somebody from the department really looked carefully at the deed, there might be some risk that they would say, oh goodness, this means she was never eligible, there is an overpayment. I don't know how likely that is to actually happen. I have not heard of it happening, and I know that there are other South Philly trust deeds out there. But it's something to think about. If she now wants to change the deed, to just change it to be adding her son as just a plain old joint tenant with right of survivorship. So the question is, does this create a period of ineligibility? And I think the answer is no. It's okay because he's disabled, so that's a permissible transfer. If he were not disabled, you'd need to look at the other exceptions and see whether any of them apply. And if not, it could create a period of ineligibility. Other things to think about is whether the transfer to the son impacts his Medicaid eligibility. And so, and I think a question here to figure out is, was it his primary residence before entering the nursing home? Because he can own a primary residence and still be eligible for Medicaid for long-term care. And it sounds like he was living there before he went into the nursing home. So if so, I would think that he could have his name on the deed to that house, and it would be considered his primary residence too. He would need to, in order to have a property considered your primary residence when you're in a nursing home, you need to sign a statement of intent to return home. It's just a form that the welfare department gets everybody to sign if they are own a home and are in a nursing home on Medicaid. And it's just something saying, yes, I intend to return to my home, because that's what makes it possible for them to not count the home as an asset, because it's your primary residence to which you intend to return home. It does not matter how unlikely it is that you would ever return home. You just have to sign the form. And DHS is happy to assume that you intend to return home, and therefore that your primary residence does not count as a resource. And so I would think that the son could do that as well.
That,
Like we've got another question.
yeah. Andre asks, what is the impact of an unsatisfied mortgage, HEC tax, or other liens on the property when a person dies?
Yeah. That claim comes in before estate recovery. Monty Wilson was just researching this the other day. He was hoping that somehow maybe the order was reversed. But the department's claim comes subject to other claims against the property, including the mortgage. I'm not sure what HEC is, but taxes or other liens. All of that gets paid first, and the department's claim is on whatever is left.
Are there any other questions? Reverse
Any
mortgage.
other questions? Is there anything that you'd like me to explain again that we were maybe too? Oh, reverse mortgage. Yes, that definitely comes first too. Is there anything that we moved through too quickly, or that you have questions about? We'd be happy to explain it again, or more slowly, or more clearly. And then, you know, again, if you have cases in which these issues come up, please feel free to contact us to talk them through.
I just want to say thank you so much to Pam and Mike for spending the time to put this training together and for coming to give us all this information. I know it, like, everyone's sort of been really struggling with trying to navigate these as they come up more often. We're doing more tangled title work, and so then we're encountering more estate recovery issues. And it sounds like for a lot of these cases, at least in the immediate term, maybe we can all, you know, work together to get rid of it at the end of the day. But in the immediate term, for some of these cases where there's this feeling of paralysis about like what next steps to take, because you don't know how it's going to affect someone's Medicaid. Sounds like maybe doing more outreach to the department directly maybe helpful, but this has been really, really helpful. Thank you so much for coming. And I'm sure you'll get lots of questions directly from folks after this in connection with their cases.